code enforcement hearing for the city of
Recording in progress.
North Miami. Today is July 18th. No,
Oh.
July
July 6th.
July 6th. I'm sorry, I lost track of time there. And I'm Jose Smith, Special Magistrate for the city of North Miami. The Special Magistrate is empowered under the Florida statutes and the North Miami Code to hold code violation hearings. The purpose of this hearing is to determine if a code violation exists at your property as observed by a code enforcement officer of the city. If the city is not able to prove its case, then I will dismiss the case and you may leave. These proceedings are being recorded, so all persons who are speaking should do so one at a time to ensure that all testimony is clearly audible on the recording device. If English is not your primary language, then please inform me when I call your case. We have interpreters who will assist you during these proceedings. When your case is called, the property owner, agent for the property owner, and any witnesses that you may have should announce your presence. When asked, speak clearly, directly into the microphone and say your name out loud, spell it, your business or mailing address, and your relationship to the property. If you're not the property owner or an attorney representing the property owner, then you must present a notarized power of attorney or an affidavit in order to have your testimony taken on behalf of the property owner. For new cases, you will be asked for the record if you are aware and understand the violation that is being heard today, and do you understand what is required to resolve the violation? Please answer accordingly. The city will present its case first, and then the property owner or violator will be given an opportunity to testify on their behalf. Bring witnesses forward to testify and present evidence and photographs and to cross-examine the city's witnesses. Following the case presentation, I will issue findings of fact on the case. If I find that a violation of city codes exists or existed at your property, then depending upon the case site, I will set an abatement date for the violation to be resolved. Or for repeat violations, I will impose a daily fine amount. For new non-repeat cases, my order will include an abatement date by which you must resolve the violation and a daily fine amount that I may impose at a future hearing should the violation not be cured by the abatement date. If I find sufficient cause to postpone the enforcement of action at this time, I will table the case or continue it to another hearing date in the future. If you do not agree with my findings of fact or my ruling, then the property owner may appeal the administrative order on the case to the circuit court. An appeal must be filed within 30 days of the date of the execution of the administrative order to be appealed. In accordance with Florida law, if a person decides to appeal any decision made by a special magistrate with respect to any matter considered at these proceedings, then the person will need a verbatim record or a transcript of the proceedings. This record includes the testimony and evidence upon which the appeal is to be based. The cost of obtaining the verbatim record shall be the sole responsibility of the appellant, and it is recommended that persons who plan to appeal their case should provide their own court reporter at these proceedings. Pursuant to city codes, if the city of North Miami prevails in prosecuting a case before the special magistrate, the city shall be entitled to recover all costs incurred in prosecuting the case. The current cost assessment amount is $100 per case. Once the city reports an order that imposes a fine and authorizes the placement of a lien against the property, then the city will charge additional administrative fees to report and release the lien. At this point, I will turn it over to the clerk and or a police officer to administer the oath. And later I will ask the city clerk to tell me if there's any additions, corrections, or deletions to the agenda. So, Madam Clerk, your turn.
Yes, Magistrate, can you hear me?
Go ahead.
All right, we have the officer here who's gonna administer the oath. Can you guys hear me?
Is the officer present?
I'm present.
Very well. Anyone and all who are going to be giving testimony at today's hearing, please stand up and be sworn.
If you are giving testimony today on a case, please rise and raise your right hand as I issue the oath. Do you swear or affirm that the testimony you are about to give in these proceedings will be the truth, the whole truth, and nothing but the truth? If so, say aloud, I do.
I do.
Are the translators ready?
Yes.
It's only one? Okay, I see. Okay. Do you solemnly swear or affirm that the translations which you are about to give in these proceedings will be accurate and correct to the best of your knowledge, skill, and ability? Say I do.
I do.
Thank you.
I-
We're going to proceed with the Pledge of Allegiance. Put your right hand over your heart. I pledge
Pledge
allegiance
allegiance
to the
flag
flag
of the
of the
United States of America,
to the
to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you.
All right, let's hear any additions, corrections, or deletions to the published agenda.
Yes, there is, Magistrate. I'm going to go ahead and proceed with the instructions for today's hearing. Thank you for participating in today's special magistrate hearing. I'll review the process by which today's hearing will be conducted. Make sure your device is muted at all times unless you are giving testimony on a case. If you are using two devices to participate in today's hearing, be sure your audio is only enabled on one device. When your case is called, if you are signed in into Zoom, you will receive notification giving you access to the audio and video so that you may give your testimony. If you are physically here in person and wish to give testimony, you must sign in with the clerk up front and await a text message indicating your case is ready to be heard. Upon receiving that message, you should immediately come to the Code Compliance Office to be provided access to a computer. If you would like to speak on behalf of a case, once the case is called, you should click the Raise Hand button to be acknowledged. Before giving your testimony on your case, please state your name, property address, and relationship to the property. If you wish to have an interpreter assist you during your case, please indicate that when the case is called. And that concludes the instructions for today's hearing, Magistrate. And to proceed with the deletions from today's agenda, which is item number 23.
We are deleting item 23.
Yes, it's in compliance, which is Gina A. Vargas and Julieta D. Manette. Case number is RCCOR 2019-00041. That case has been in compliance.
Okay. Any other changes?
No, that was all the changes for today's agenda.
Okay. Is the city ready to proceed?
Yes, we are.
All right. Are we starting with number one?
As far as for number one, we're gonna go ahead and not start with number one, but rather start with number 23. Well, not 23, 25 and 26. What do we have here for it? Amanda. Let me go ahead and check the attendees queue to see who's here.
25 and 26 is
Yes.
Blau House.
Yes, the attendee was here. For some reason, I'm not seeing her in my queue, but I am going to go ahead and advise. I'm going to allow Romina Gastelou to speak. I'm going to promote her to panelist.
Okay, spell the last name.
Gasteleu.
Good morning.
Good morning, Romina.
Yes.
Give me 1 second. I'm going to allow you to enable your video. We could hear you, but we cannot see you.
Got it.
Here we go.
Are you here for the Forest Place LLC property?
That is correct.
That property is not scheduled on today's hearing. It's actually on the September 7th hearing.
Oh, September 7th?
Yes. So you do not need to remain in this hearing.
I appreciate it. Thank you so much.
You're welcome.
Bye-bye.
Okay, I'm gonna go ahead and promote Ms. Valencia to panelist.
Don't see anybody yet.
Yeah, she just accepted it.
Okay.
Ms. Valencia, please enable your audio and video.
Hello, good morning.
Good morning. What's the property you're here for today?
It's 880 Northeast 128th Street, North Miami, Florida 33161.
What's the name on the property?
It's under my name, Michelle Valencia.
What number is that, Madam Clerk?
I'm looking through the agenda currently. Ms. Valencia, provide me with the address one more time.
880 Northeast 128th Street.
It's closed. So your officer, Jonathan Lemestre, just advised that that case is closed. So you do not need to be here in today's hearing.
Okay, appreciate it. Thank you.
You're welcome.
Bye.
And we have one more attendee in the queue, which is Ludi Burnett. And then that is item number 29, Magistrate.
Okay. Ludi Burnett,
Yes.
and that's 215 Northwest 121st Street.
That is correct.
Hello. Okay.
Good morning. We could hear you and we can see you. Can you please, both of you guys, raise your right hand?
Living Mill.
Do you need an interpreter?
Yes, please. Creole.
Creole? 1 second. Creole interpreter?
Good morning.
Good morning.
Yeah.
I'm going to go ahead and sort them in, okay?
Please do so.
Bonjour, les patrons à l'aise, s'il vous plaît.
Good morning. Do you solemnly swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth? So help you God. Please say I do.
Est-ce que vous jurez solennellement que le témoignage va être pendant ça c'est la vérité, seulement la vérité, rien d'autre que la vérité et que bon Dieu n'aide? Dis oui, s'il vous plaît.
Oui. Yes.
I
Okay. I'm going to call the case into record. Item number 29, Lou D. Burnett. Case number is CEBPR 2022-00608. This case was previously found guilty with an abatement date of June 15th, 2023. Fine was set at $500 plus $100 cost assessment, and the officer is Shanna Sanders.
Ms. Sanders, are you here?
Yes, I am. Good morning. Good morning.
Okay, first let me have the property owner identify himself one more time for the record.
Bon, et est-ce qu'on peut identifier tête ou encore, s'il vous plaît?
Ludi Vernet.
Lodi Vernet.
And your property address is 215 Northwest 121st Street?
Oui.
Et adresse propriétaire, c'est 215 Nord-Ouest et 121e
Northwest
Street.
121st Street.
121e Street.
Oui.
Do you understand why you're at this hearing?
Vous comprenez pour qui ça rencontre ça là?
Oui.
Yes.
Je comprends.
Okay. You understand that you have not yet complied with my order of May 2023 regarding a permit for a shed, a detached structure on your property, correct?
Et vous comprenez que jusqu'à présent, vous êtes en règle et par rapport à l'ordonnance que vous avez bail en mai 2003 concernant permis besoin.
You're breaking up. Like she can't
Et pour
really hear you.
Mr. Interpreter,
can you hear me?
could you repeat the question?
Absolutely. Et vous entendez là?
Oui.
Ok, est-ce que vous comprenez que jusqu'à présent, en règle par rapport à l'ordonnance que vous avez bail en mai 2023 concernant permis qui ont besoin pour celle qui est tachée dans la propriété là?
Oui.
Oui,
Yes.
les comprendre.
She
Mais
understands.
là, t'es déjà là. It was already there. That's the problem.
All right,
They're just fixing it up.
let me ask that the other person who's been participating in the case identify himself.
Hello, my name is Tyrone Vernet. I'm her son.
Okay. All right. I heard what you said. You said that the fence had been there before.
Yes, it's a shed in the back.
Yeah, but you were found guilty because the fence that was constructed, or the shed rather, not the fence, or the structure, was originally built without a permit. Do you understand that?
Yes.
Okay,
No.
I'm gonna that's just need to have a yes or no answer. Let me hear from the code enforcement officer regarding the current condition of the property, and I'd like to know whether or not the property is currently in compliance as required by my court order.
Shanna Sanders, Neighborhood Service Inspector. No, compliance has not been met at this time.
Have you had an opportunity to discuss it with the property owner?
I met with a gentleman there at the property. He identified himself as the property owner. Interpret if you want to relay that much so far. That I did meet with a gentleman there. He identified himself as a property owner. He fully understood that a permit was needed. But again, at this time, my last inspection, compliance has not been met.
Okay, can you show for the record a photograph of the condition that led you to issuing the violation?
May I go ahead and
Please do.
thank you. Que les Sanders qui fallait officiellement là et que magistrat a posé question qu'on et alors par rapport à la direction est-ce que donc si c'est que normalement il y a les propriétaires il rencontré avec un homme qui était c'est les propriétaires et il était content que mi qui est nécessaire et pour barrage là et jusqu'à maintenant par dernier ce que le fait et nous toujours pour
Mr. Burnett or Ms. Burnett?
Yes,
How do
she's the
how do you
only
respond?
owner. She's the only owner. There's no other owner. She wasn't properly told of the situation. She
Well, it's too late because I've already entered an order at a prior hearing. So it's too late to challenge that. She obviously lives there, and there's a structure that was built without a permit. Does she not understand that?
non li yo ti jan trop kounya parce que yo d'autres qui gen tombé dans des applications qui fait et clairement au habitant gen une structure qui construit sans permis. Comprendre ça?
Oui, m'attendez.
she can't
Yes,
hear
sir.
you, like you're breaking up. The
Sure,
audio is
go
breaking
ahead.
up.
Please
Oh, you can hear
repeat,
me?
Mr. Interpreter, please repeat the question.
Sure. Ok, normalement, il y a un temps parce que gagne une ordonnance comme des dans la dernière apparition qui était faite là. Clairement, c'est là que on habite et gagne un switch qui construit là, c'est pas de gain permis pour lui. When
Oui.
yes.
Okay, is there any reason at this late date why she does not have a permit for this structure?
Et est-ce que il y a une raison qui fait que jusqu'à présent et après tout temps ça, on a gagné permis pour structure ça?
Li te la deja, se yon bay ki te la deja nou refel. Te toujou, dan kou nan mezon, toujou gen yon depo pou mette bagay yo. Sa vezi te la deja se fe nou refel. Kon ya nou tale pou nou, yo te mande nou yon, epi nou fe li. Yo voye l ba nou. Men sa nou, si ti a te mande nou bay li lontan, men se kon ya mwen yo voye l ba konen, yo di swal pa bon, men yo pa di nou pa bon. Nou pa konen si pa bon. Se kon ya yo di pas bon lè nou te bali la yo te pran yo te di OK.
It was already there. We just had to rebuild it, but the structure was already there. And when we were doing it, we determined what was requested, and they did tell us that it wasn't good. Now they say again, but at the time when we turned what was requested from the city, they didn't say anything about it.
Who
All right,
did she,
go
did she
ahead.
request something from the city? She said, who did she request something from the city in reference to the shed? What she had was a manufactured store-bought shed that was broken down, and she literally erected this shed from scratch, from the ground up, with no permit. So I don't know who she spoke with to the city that said this was fine, but code and myself specifically told her, if not the gentleman, that a permit was needed.
You, Madam Code Officer, Ms. Sanders, have you had conversations with Ms. Burnett?
When I initially opened the violation in July of last year, she was at the property when I first came. A gentleman who identified himself as property owner stepped out the door with her because it was a language barrier just as it is now, and he interpreted, and yes, it was fully understood that a permit was needed.
No.
So through the gentleman, through conversation at the property with her, me and him, it was explained that a permit was needed.
And as of this date, there has been no communications between the property owner and the building department. Is that correct?
Not from what I'm showing in the computer, no.
Okay. Is the building official present?
Yes. Good morning, Special Magistrate. I'm Mayor Jean. I'm present.
Yes. Mr. Building Official, is there any record in the building department of the property owner having made any effort whatsoever to apply to request a building permit for that shed or that structure?
I don't have anything now. I would have to look quickly at the address, but if Ms. Saunders took a look at it and if there was nothing on there on
Okay.
the system. Yeah.
So what I'm going to do is I am going to ratify the fines and authorize the city to impose a lien. Maybe that'll send a message to the property owner that orders from a special magistrate mean something, and that when you build something in the city of this nature, you need to have a building permit, because otherwise you're going to be in violation of the city code. So based on the testimony of the city's code compliance officer, the building official, the photographs and other evidence presented to me that the property has been out of compliance since the abatement date. The abatement date was June 15, 2023. I hereby find in favor of the city and ratify the fines accrued to date, the amount of $500 per day, and assess costs in favor of the city. Authorize the city to file a lien on the property. The fines shall continue to run on a daily basis until there is compliance. So we're done with that case. Let's move on to the next one.
Magistrate, before you move
sorry,
on, let
can
him
you
interpret that. Yeah.
Okay, yes,
Thank you.
Apologize.
Ok, donc, une question qui t'a faite et avec et département et construction qui c'est Margine pour vérifier est-ce que dans le système là il y a un rapport de communication ou même avec le bureau. Et avant ça, il y a une question qui était posée à l'officier Shana Sanders pour connaître est-ce qu'il était en communication avec vous direct et Madame Vernet. Et il était répondre que et premier jour et qu'il était allé l'autre bon il était rencontré avec vous, il était là et puis il était un autre monsieur, l'autre jeune homme et qui était sorti avec vous et puisque tu as un différence langue ou même avec lui. Donc monsieur a été traité pour vous et on t'a communiqué et toute bagaille était claire, on t'a comprendre. Et après, par exemple, et l'autre communication à nos jours, donc le magistrat lui-même, il a décidé que par rapport à tous les témoignages qui baillent là, de officiers et code avec toute image qui montre là, toute évidence qui paraît que ou toujours par règle et que il a ratifié paiement qui était déjà posé à partir de date et que dossier en théorie qui c'est 15 juin 2023 et donc décision à prendre en faveur si bureau Villan côté que et au gain une amende de $500 qui a accumulé par jour puis plus frais et plus frais et pour travail dossier. Donc, on a gagné un droit et pour lui poser en ligne sur propriétaire. Et puis, frère Amad lui-même, il a continué à augmenter de jour en jour, c'est $500 par jour.
Pas fin comprendre ça dit bien. Parce que grand monde sous caisse là que dépôt était déjà là déjà, c'est refait nous refait lui. Il était déjà là déjà, toute maison supposée gagner un dépôt, il refait et puis que nous grand monde sous caisse là cap régler ça, l'en aller yo te mandé comment les barrer là même serveur à nous bail, c'est ça yo te mandé là nous venir yo dit nous pas de gain nous bail. Qu'on y a nous grand monde sous dossier. C'est lui qui a régler dossier mal côté mon yo dit que parole vini me les messieurs li parler li dit oui sous que ça la régler. Mais comment pour me payer 500 combien $, et puis mettre une sous lui, moi ça va faire. Toute maison suppose de grand dépôt.
I don't understand what
Mr. Interpreter, please interpret what Ms. Renee just stated, and then we're going to end it right there because I don't want to keep going back and forth.
Et m'a fini après dire Madame Vernet, après ça n'a pas obligé de finir là parce que nous pas capable faire aller venir sur ce sujet. And so I don't understand what you just said because, like I said, the structure was already there. We just had to rebuild it, and we have someone working on the case. And we provided the survey that was requested. And when I spoke with the person, they said that they are working on it. So I really don't understand because every house deserves to have a shed, and so we just had to rebuild it as it was there already. So I feel like this is not fair.
All right.
Pou
Please.
gen yon kesyon,
No,
mwen
no,
gen
no,
yon
no.
kesyon.
I'm done. I'm done. I'm done. No, no more. No more. Any further comments or requests should be directed to the appropriate city official, whether it be the finance director or the city manager. We're done here.
Et moi, capable en plus, nous finir là, et n'importe quel commentaire ou question que vous avez gagné, capable de retirer directement à un officier et bureau. Il est capable de mon département finance et directeur ou bien dans gérance là. Et mais nous-mêmes, n'a fait là.
Interpreter, just make sure she knows to visit the building department. You know, I understand she's saying, you know, whoever she has working on it is saying it's done. You know, have her to make sure that they have indeed submitted the application, because I don't see anything even as we're speaking. So, you know, I just want to maybe reiterate, visit the building department before anything else to confirm what her handyman, contractor, whomever is saying is indeed correct.
Et puis avant tout, m'a clarifier pour vous, avant toute bagaille, l'important pour ta vérifier dans le département construction, parce que si moun ou gen qui travaille sur le sien pour en dire que y a travaillé sur lui et que ça fait, et moi-même pas rien dans le système là, donc il est important pour ta vérifier et que ça audio là est correct et assurer que tu vois l'application effectivement.
Ki mwen mèm se, moun nan soma avèm ki pou ale nan siti ya pou nou kapap klarifiye sa, bon mpa gen yon kom ka fe. Paske moun nan la, li di la pregle, e mwen mèm san soma avèk, mwen ta ansama avèk li.
Well, in this case, all I have to do is maybe go to the city with the person, because I don't see anything else I can do, because the person says they're working on it, and I don't see anything else I can do myself.
Well, that's indeed what I'm saying. She needs to come and visit the city, you know, and confirm that. Come with him so that she can confirm that it's indeed being submitted to the city. You know, until then, as the magistrate said, the fines are running.
C'est exactement ça, oui, que moi dis là. Et on va venir dans le bureau, villa avec mon nom, pour capable vérifier que ça audio là effectivement li fait. Et mais sinon, et ordonnance magistrat lui-même, li a été en effet, et amende lui-même, li monte.
Okay. I just want to make sure she fully understands so that we can move on to the next case. But, you know, visit the cities and make sure, okay?
D'accord, donc je voulais sûr que vous compreniez bien ça m'a dit là avant que nous avancions. Donc, on est juste aller dans le bureau ville pour capable assurer de ça, ok?
D'accord.
All right.
Thank you.
Welcome.
Merci.
I need to step away for a minute or so, okay? Just hang on.
Sure.
Sir?
Sorry, this is okay. Sorry.
All right, I'm sorry. I had to take a very important phone call. Let's move on to the next case, please.
The next case is item number 3, 1330 Apartments LLC. Case number is CEMHS 2022-00391. This case was previously found guilty with an abatement date of March 16, 2023. Fine was set at $500 plus $100 cost assessment, and the officer is Shannon Sanders.
And who's here on behalf of the owner?
We have Andrea Andrada.
Okay. Ma'am, would you please identify yourself for the record?
Please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth? So help you God. Please say I do.
I do.
Your name, ma'am?
Andrea Andrada.
What is your relationship to the property?
I manage this property for the owners.
Okay. And the owner of the property is 1330 Apartments LLC?
Yes, sir.
And who is Fuego Nova LLC?
Fuego Nova is the manager of this company.
Okay.
Fuego Nova is from Delaware. That's we had 1330 in Miami-Dade in order to do business here.
All right. And you're authorized to speak on behalf of the owner of the property?
Yes.
Okay. Do you understand, ma'am, that a former or a prior special magistrate found the property to be in violation back in January of this year and gave an abatement date of March 16th, and we're still hearing the case? What has happened since the prior magistrate entered her order?
Okay. We submit the permit. Permit was denied, and it was requested that the engineer has to revalidate the letter that he submitted, and the contractor has to speak with the inspector to see what he need, what else he need in order to have that permit approved. So as I understand, he went to the city and he spoke with the inspector, the building inspector, but I don't have any communication with him this week. He told me he will be here with me today at the hearing, but unfortunately, I can't reach him. He's no answer me. So I'm in the middle of two people that they have to do something, and unfortunately, I'm stuck in the middle because
okay, all right.
we have to resolve in some way.
I first of all, the person you're talking about is not present. So anything you say about what he told you or didn't tell you is hearsay, and I place no credibility on somebody who's not present telling you that he went to the city and did something. So I'm going to hear now from Shana Sanders about what the current situation is with respect to this property, and I'd like Ms. Sanders, for the record, to show me the railings, the stairs, the treads, and the conditions that led to the entry of an order back in January of this year, which to date has not yet been complied with. Ms. Sanders.
Shannon Sanders, Neighborhood Service Inspector, was originally cited and already adjudicated. The case went before, I think, the previous special magistrate, whereas it was found guilty. They were instructed to visit the building department. Upon doing my neighborhood, annual housing inspection, I observed railings that needed some repair. They were cracks, some unsteadiness, shakiness of the railings, and things of that nature. Long story again, they came before the magistrate, was found guilty, was instructed to obtain a permit. As of the reinspection, a permit has been submitted. They were denied, and they were instructed as of in March of the denial and was told to visit the city to make some corrections. She said someone came to the city. I don't see any notations in the computer for that, but you know, that's why I wanted to go ahead and move forward with presenting this case, because again, they were notified March 22nd to visit the city and to make the necessary corrections. And as of today, those corrections have not been made and the violation still remains outstanding.
Can you show me those steps again and the lack of treads? That there's supposed to be treads right across the railing, and that's to keep people from slipping and falling, right?
Yes, it is. Yes, it helps with, you know, slippery along with the railings. I'm not sure if you see it on the left-hand corner, you know, it's rusted, you know, needs a little, you know, TLC there, needs some little replacement, restabling and things of that nature. They were a little shaky and rusted.
Yeah, well, ma'am, I'll call you on you in a minute. If those railings are as bad as I, you know, as I see them, and you're telling me they're a little shaky, it's more than just a little tender, loving care. I think it really needs radical correction. And in my mind, and this is a multifamily building, young people living in that property.
I have seen young adults and young children getting off the bus upon my inspections and re-inspections. As you see here, some bikes up under the stairwell. So, and I have seen kids here.
Yeah, and I suppose that based on those conditions and the safety issues, I suppose that's why the prior magistrate set the fines at $500. I'm going to give the agent for the property owner, since she has her hand up, to explain to me how those conditions have been allowed to remain on the property since January of this year. Ma'am?
Yes. Okay, that picture, it was for 2022, which I mean January 23 also. It was before the violation, but all of that in no condition, actual condition, because all of that the engineer considered that was maintenance. Everything is done.
And magistrate, what she's stating, those pictures were taken at the time of the initial violation, as well as throughout some re-inspections. However, they were done without permits, and as you stated,
exactly.
It needed a little more than just some TLC, and that's what the previous magistrate did state, as well as I believe the building official spoke a little bit on this, and it was instructed because more than just TLC was needed, they were advised to visit the city and obtain a permit. So that's where we're standing at. Not so much that compliance has not been, with that the repairs haven't been made, is now they've been remade without the proper permits.
Correct.
On file, because you know the city needs to make sure that what was done correctly.
Exactly. So the maintenance was done, but then it was requested a permit. So we submitted a permit, and the permit is denied, and they have to put paper together. But the maintenance is done already. It doesn't look like that.
Ms. Sanders, the railings issue, has that also been repaired?
You know, I would say, and to answer specifically, I would say yes and no, because I would say partially visually looking at it, it seems to be repaired. However, no permit has been obtained. So, you know, for me to say compliance has been met, I would say no. They submitted a letter, as we're saying here, you know, on file, but the permit has not been obtained. So no, compliance has not been met.
Do we know what? Do you know why the permit was denied?
Yeah, I could pull it up here. I looked in the computer as we were, you know, starting to discuss. It shows that in the details, when they submitted the application, seems as though they kept it, you know, real sketchy, and it was more so just stating repairs to railings were made. But it seems like the building department is asking for them to be detailed in their description as to what exactly was done. I want to read it, you know, I want to be precise in what they're stating. They need to provide detail on specs of what repairs were made to the railing. I'm showing, and that was by the building department, I'm showing flood stated Please provide itemized estimate to include all work costs of the project, labor, materials included, and estimated value of donated and discontinued materials. They had several things, and then the next department, structural, denied it, saying they needed the letter from the engineer. Again, must be specific, that no resign, RESIN, and construction was done on ratings. You know, that way they were informed of that denial. I'm showing here 3/16 and 3/22 being March 16th and 22nd, but as of then, nothing has been done.
All right, so I have a better understanding now of the case, in that you're telling me that the repairs have been made, and I can tell from some of the pictures that you showed me, but that even though repairs have been made, there has not been a building permit issued, nor has there been a final inspection yet. Is that
That's exactly what's happening, Magistrate.
okay? So they've made some effort to comply. My only concern is whether or not what they have done, even though they've done it without a permit, whether or not what they've done makes the railing situation safer for the tenants of this building.
And that was the stance of the previous magistrate, because that heard the case, you know, and that's why we gave them this 3-month time to pull this permit and show that that was done. But here we are, July 6th, with the same conversation stating we're waiting for the missed individual to visit the city and provide that information.
Yeah, and so you're seeking a ratification of the fines, correct?
Yes, you know, hopefully that'll get some type of movement and made and get this permit obtained. Yes.
Yeah, what bothers me about some of these cases, and I'm not picking on this one in particular, is that we have a so-called manager showing up at a very important hearing where a significant amount of fines have been made by a prior magistrate. We don't have any engineers, we don't have any contractors. The actual owner didn't even bother to show up, which to me is a sign of disrespect to the magistrate. And so I am going to adjudicate, and not adjudicate, I'm going to ratify the fines, and maybe that will shake them up and get them to hire a real licensed, insured contractor, engineer, or architect to get these plans through. Please mute yourself for a minute, and then maybe we'll get something done, because it's been too long. It's been over 6 months, and so I am going to enter the following ruling. That based on the testimony of the city's code compliance officer, the photographs and other evidence presented, that the property has been out of compliance since the abatement date of March 16, 2023. I fine in favor of the city and ratify the fines accrued to date in the amount of $500 per day, and assess costs in favor of the city, authorize the filing of a lien against the property, and the fines shall continue to run on a daily basis until there is compliance. That's my order, and I'm ready to move on to the next case.
Thank you, Magistrate.
Magistrate, we don't have any more attendees in the queue. As they come in, I'll try to call them in, but we'll go ahead and proceed with the order
We'll
of the hearing.
proceed. If they are not present, I will grant a default against the city or whatever other relief the city is requesting. Ms. Andrada, we're done with your case. Thank you.
Thank you.
Next case.
Magistrate, I'm going to go ahead and proceed with item number 1 and 2. Item number 1 is 13020 Northeast 6th Ave, Prestige in Prestige, East Property Management LLC. Case number for item number 1 is CEFOB 2022-00167. This case was previously found guilty with an abatement date of January 12, 2023. Fine was set at $250 plus $100 cost assessment. And for item number 2 is for the same property owner. The case number is CEZCU 2022-00349. This case was also previously found guilty with an abatement date of January 12, 2023. Fine was set at $250 plus $100 cost assessment, and the officer is Shanna Sanders.
All right, we have 2 cases. The first one deals with a business tax receipt. The second one deals with a certificate of use. Is there anyone present for the property owner?
Not at the moment, no.
Okay, let me hear from the code officer.
Shanna Sanders, City of North Miami Neighborhood Service Inspector. This case was originally opened by now retired Code Officer Aaron Barber. It was, given to me, upon her, retirement from the city. I looked in the computer, from my inspection and reinspection of the property. I am noting that the business tax receipt has not been obtained at this time. My last reinspection of the property was, I'm showing here June 15th of 2023. And again, no business tax receipt has been obtained at this time.
What kind of business is it?
This is an apartment building. I don't know. I could look really quick to see how many units, but it's a, I guess I would consider maybe small to medium size apartment building along 6th Avenue.
Okay. The state is showing a manager by the name of GP19 Management LLC. Have you spoken with anyone from management regarding the violation?
I would be honest enough to say, let me just look at this. I want to make sure because I got some of Aaron's cases. This one, no. This was originally opened by now retired Code Officer Aaron Barber. It was just given to me as a follow-up. We have quite a few pending, violations in the computer. So some of these, with the business tax receipts are kind of easy to just look and see if compliance has been met. I did post the property for the notice to appear, hoping that someone would give me a call and say, yay, nay, permanent, business tax receipt has been obtained. We're submitting the application, something to that effect, but no conversation has been had. No phone calls were made to me. As we see today, no one is present. So since I've been addressing and handling this violation, I myself has not had any contact with anyone from this building.
Okay. Have you looked at the file to determine whether or not there's proper service?
I myself gave proper service. I did post the property with the notice to appear. I did look at the files, just to kind of get a, little understanding. Prior notices were made from what I visibly see, correctly. So yes.
All right.
Magistrate, and
yes.
also there was also a copy of the notice of the initial notice of violation mailed to the registered agent. That's on the Sunbiz. So
Okay.
here's the affidavit, and below is the mail certified number that was handwritten by Ms. Barber.
All right. Based on the unrebutted testimony of the city's code enforcement officer and other evidence presented that the property has been out of compliance since January 12, 2023, which was the abatement date, I find in favor of the city, hereby ratify the fines accrued to date in the amount of $250 per day plus $100 cost assessment. The fines shall continue to run on a daily basis until there is compliance, and the city is authorized to file a lien against the property.
Special Magistrate, if we can, I would like to go ahead and proceed with the second case because it's for the certificate of use. They kind of go hand in hand. You can't, obtain one without the other. I can give, full testimony just as I did with the business tax receipt. Case was previously opened by now retired code officer Aaron Barber. Upon my inspection of the computer, and speaking with the coordinator for the certificate of use department, community planning development, compliance has not been met. They have not submitted an application. Notice of violation, notice to appear, were all mailed out, certified mailed and posted at the property. So I am showing proper service was given upon my last reinspection on June 15th. No application has been submitted to the city and no certificates or documents have been obtained at that time.
All right. Is the city attorney present?
Yes, we have a new assistant city attorney. Her name is Paul Marie Bob. She's here.
Okay.
I'm Special Magistrate.
Hi, welcome. I would like to recommend to the city attorney's office, together with the with code and staff, on these cases where there has been a ratification, a lien, and everything done appropriately, that not only do we serve the registered agent, which sometimes is a waste of time because they may be even out of business or don't care, that perhaps a better way to get their attention is to notify the individuals who have a membership interest or an ownership interest. In this particular matter, it's a, is it an LLC? Yes, it is. And also, if and when you file a lien on the property, if you could notify the lender, which often helps, because by filing the lien on the property, the lender then has a stake and may facilitate compliance, being that a lien on the property may cause a default in the mortgage. So, I don't have a problem with a ratification and authorizing the filing of the lien, but I also would go one step further and notify the individual owners and the bank so that they're aware and they can't come back later and say, we didn't know. So, the more people involved with the property that know about these lien cases, the better will be. I think we'll get more compliance, and the sooner these violations would be rectified. So that's just my recommendation. You're the assistant city attorney. You act as appropriate, but I think to get their attention, we need to do more than just serve the registered agent.
Got it.
Okay. All right. Based on the unrebutted testimony of the city's code enforcement officer, and we're dealing with a certificate of use issue right now on the property. The evidence presented depicting that the property has been out of compliance since January 12, 2023. A fine has been previously set by the prior special magistrate at $250. Property is still out of compliance. I ratify the fines accrued to date and assess costs in favor of the city. This fine shall continue to run on a daily basis until there is compliance. So we're ready for the next case.
Magistrate, we're going to proceed with item number 4 through 6, which is 125 Northeast 125th Street, Prestige Point. Item number 4, case number is CEFOB 2022-00169. It was previously found guilty with an abatement date of January 12, 2023. The fine was set at $250 plus a $100 cost assessment. Item number 5, same property owner, case number is CEMHS 2021-00034. This case was previously found guilty with an abatement date of June 3rd, 2022. Fine was set at $500 plus a $100 cost assessment. And item number 6, same property owner, case number is CEMHS 2021-00037. This case was also previously found guilty with an abatement date of June 3rd, 2022. Fine set at $500 plus a $100 cost assessment. And the officer is Shanna Sanders.
Okay, I've reviewed the 3 files, so you don't have to go into a lot of detail. Just briefly tell me about the first case, case number 4, 1525 Northeast 125th Street. And the first one has to do with the business tax receipt.
Shanna Sanders, Neighborhood Service Inspector. It was originally cited by the now retired Aaron Barber. As of my last reinspection, the business tax receipt has not been applied for, nor has it been obtained as of June 20th was my last reinspection of the property, and at that time, compliance has not been met. I am showing proper service was given. Certified mailing was mailed out to the property owner and or all respective agents of the property. I myself as well posted the property with the notice to appear. I spoke with a woman who identified herself as the manager, who stated they would submit an application, but again, as of my last reinspection, nothing has been submitted to the city. So I would like to move forward with ratifying these fines.
Okay, the property is
an apartment building.
Apartment building with tenants.
Yes, it is a fully occupied apartment building.
Okay. All right, on the business tax receipt case, I find that based on the testimony of the city's code enforcement officer and the evidence presented, that the property has been out of compliance since January 12th, 2023. I find in favor of the city and hereby ratify the fines accrued to date in the amount of $250 per day, plus a cost assessment in the amount of $100. The said fines shall continue to run on a daily basis until there is compliance, and I authorize the entry of the filing of a lien against the property. The next case is number 5. Again, the same owner, and this seems to be a more serious case of exposed rebar, problems with balconies. Tell me a little bit more about the condition on the premises.
Shanna Sanders, Neighborhood Service Inspector. Again, this violation was originally opened by the now retired Code Officer Aaron Barber, given to me, upon her dismissal retirement to the city. I myself inspected the property. When I posted a notice to appear in for the reinspection of the property, whereas I observed balconies that were in disrepair, disrepair and or needed some repairs. I saw some stucco work, again, some rebar that was exposed. At that time, I called the number that was on the front of the building to, see if I can make contact myself with an individual, again, seeing that it was handed, this wasn't my initial violation. The lady on the phone who identified herself as the property manager stated that she was not aware of the violation, but that she would be on it and take care of it. Again, as of my last reinspection, nothing was addressed. It still remained out of compliance. I would like this case, just as the previous one, to go ahead and be ratified with the fines. As you're seeing here in the pictures that I took on June 20th, pictures of the balcony, whereas parts of it is falling apart, it's exposed, at least a little, till needs some work done, needs some work done.
Seems like needs a lot of work done, but you see any safety issues there with property owners possibly being subjected to a potential disaster?
Right now, really, I'm no, building inspector, but just looking at it with the exposed rebar and parts of it falling apart, we're upon heavy, we're in hurricane season. Any strong wind, gusts, things of that nature could possibly, be very damaging. We have the building official here, on the Zoom. So, he might be more detailed in giving that type of information, but visibly looking, it looks, bad to me, to the eye.
Yeah, obviously I'm going to ratify the fines, but I would like the building official to keep his eye on those balconies and those railings and the exposed rebar, because as you stated, with hurricane season and other perils that may come up, I don't want people getting hurt, and I don't want the city taking the blame for it for not enforcing the code. Mr. Building Official, you have the authority to red tag the building, don't you?
Yes, correct. And Mr. Magistrate, I was aware of this one. Actually, I did the review of the permit application that was submitted, but it's currently denied, but haven't had any action on this since this was July, almost going to be a little shy of a year ago.
Yeah, well, I feel terrible for those tenants that may have to be forcibly removed from the building, but I want you to be aware that you have the sole authority and discretion to declare this property an unsafe structure, red tag it. That's not my responsibility. All I can do is lien it, impose the fines, etc. But I'd like you to keep a close eye on these violations because I'm concerned about the tenants that are residing there. So based on the testimony of the city's code compliance officer, the photographs and other evidence presented reflecting that the property has been out of compliance since June the 3rd, 2022. I find in favor of the city, hereby ratify the fines accrued to date in the amount of $500 per day and assess costs in favor of the city. The fines shall continue to run on a daily basis until there is compliance. I note also for the record that this was my order that was entered. And if these orders are going to mean anything, I would like the city to, take strong action to make sure that these conditions are not allowed to exist. I'm not all that concerned about the prior violation with a business tax receipt. To me, that's not a big deal, but these kinds of conditions are of major concern. And so I'd like the city to, again, Madam Assistant City Attorney, let all the owners and members and anybody that has any interest in this property, not just a registered agent, but everyone that has any proprietary interest in the property to know that these $500 a day fines are being assessed, and that's a heavy hammer that they'll have to deal with. So based on that, I think we're concluding this case. I think we have one more involving the same property. Madam Clerk, please proceed with telling me about the next case, number 6.
I'm Shannon Sanders, Neighborhood Service Inspector. This one is CEMHS 2021-00037, minimum housing inspection in violation of the elevators. This case was originally opened by now retired Code Officer Aaron Barber, whereas an adjudication was already made, given to me. As you see, as you say, you've already looked through these cases. It's been open and pending since January. So addressing some of her pending files, I re-inspected the property when I posted the notice to appear, whereas I was visibly saw at that time that the elevator certificate had expired. I then had a conversation, via telephone call with a woman who identified herself as a manager. She stated that they had a copy in the office, the main office, and that they would have it posted upon my reinspection. Upon my reinspection on June 20th, I was unable to verify. At that time, we had received a lot of rain within the area of North Miami. It was a lot of flood and water throughout the elevator floors. So I was unable to, inspect. Upon my conversation with that manager, she stated the elevator was not working. Due to the flood, it was out, so they had it kind of locked off. I asked her if she could at that time at least email me what she had in the main office so that I can have something for the file showing something up to date. It was supposed to happen by the close of business. The close of business has come and gone. We're now 2 weeks later. No compliance have been met. No emails have been sent to me with the new certificate. So again, past my last reinspection of the property, for the notice to appear posting and the reinspection on the 20th, compliance has not been met. The elevator certificate still remains expired and not renewed or posted.
Okay, you've told me a lot of good information. I will tell you from my experience, when you have a flooded elevator shaft, that means that the electrical components within the elevator have all been irreparably destroyed, which means that you practically need a new elevator. And that's a major problem for a relatively small apartment building. These elevators can cost up to $100,000. On the other hand, you telling me that nobody can use the elevator, nobody is able to access the elevator?
That was correct. When I re-inspected the property, it was closed off. They had the big orange cones there, and with some yellow tape, had it sectioned off, and it said, out of service. Again, I called her on the phone, because we were talking about all the violations, and she said they had just received a call 2 nights prior. She said actually the elevator people were on their way. I tried to hang around a little bit, but no one came and called, at least within the 35 minutes that I was in front of the property doing paperwork.
Yeah, the elevator is probably irreparably damaged, and they probably will need a new one. So how many stories in this property?
If I'm correct, I believe it was 3. It was 3 floors, three stories.
Does the county inspect elevators also? Does anybody know?
The elevators are regulated by the county, so they would inspect the function of the elevator as well.
Okay, I think a call to the county elevator people to get them involved as well. This is a serious issue, especially if you have disabled people, elderly people living on the 3rd floor, having to go up the stairs. There's maybe some disability issues here as well. So having previously entered an order on this case and set fines, there isn't much more I can do, but I encourage the building official to contact the appropriate county authorities perhaps the city attorney's office can also do that and let them come in and do an inspection. And it may be, again, that, you know, that something drastic needs to be done, because without an elevator working, there may be a problem with tenants on the second and the third floor. So based on the unrebutted testimony of the city's code enforcement officer, the photographs and other evidence presented, reflecting that the property has been out of compliance since June 3rd, 2022, is it? I mean, or am I reading that wrong? 2022?
Let me look and see, Magistrate, again. I'm chuckling, but I'm being honest to say these cases were old pending cases by some of the, you know, retired officers. We're trying to clean out our system. Yeah, I'm showing here 22.
Yeah, that's well over a year. And I found the property owner guilty myself back then. So the
oh yeah.
My ruling is that the property has been out of compliance since June 3, 2022. I find in favor of the city and ratify the fines accrued to date in the amount of $500 plus a cost assessment in the amount of $100. I authorize the entry of a lien, the filing of a lien against the property. The fines shall continue to run on a daily basis until there is compliance, and I encourage the city to contact the county with regard to the elevator issue.
I definitely will, Magistrate, because even as I'm looking, once you said 22, it even states here the last inspection in June 22. Even on that date, it shows the elevator was flooded due to a recent storm and was disabled at that time. So here we are a year later with the same thing that I visibly observed myself. So, you know, even whether it's through the building official or myself, we'll definitely not let the ball drop with this and get some things done and make some phone calls regarding this property.
Yeah, I'm sure they're going to need a new elevator. So that's the problem. Anything they tell you is just foot dragging. They're just trying to buy more time. I think we've given them enough time already. So let's put the hammer down.
Magistrate, I'm going to proceed with item number 7 through 11, which is 1530 Northeast 130th Street, Inc. Case number for item number 7 is CEAHI 2022-00027. For item number 7 was previously found guilty with an abatement date of June 15th, 2023. Fine was set at $250 plus $100 cost assessment. And as for item number 8 through 11, there's no adjudication on them yet. Item number 8, case number is CEBPR 2022-00612. Item number 9, same property owner, case number is CELDR 2022-0019. Item number 10, case number is CEMHS 2022-00476. And item number 11, case number is CEMHS 2022-00477. And Shanna Sanders, the officer.
All right, Ms. Sanders, let me hear from you.
Okay, and let's start with the first one for the annual housing, case number 7. Make sure I got this in order.
Yes.
This is for property address 1530 Northeast 130th Street. For the light fixtures, I'm showing upon my, just want to make sure, okay, yeah, this is the one that was adjudicated already. Upon my re-inspection of the property, I'm showing here June 18th, 2023, compliance has not been met. Just to give just a brief synopsis, this was a violation that was cited for the light fixture near unit 3 that was missing and needed to be replaced. The last hearing, I believe the gentleman was here. I believe the property manager as well was here. We had a conversation, I believe, about that. They said they would replace it. Again, upon my reinspection, it still remains missing, still remains in need of replacement. I am showing proper service was given. I posted the property with the notice to appear. Want to make sure the date. The property was posted on June 6th of 2023. Certified mailing was also mailed out to the property owner as well as the listing agent. As we see here, no one is here to represent this property, and compliance has not been met upon the inspection.
That is just not acceptable. It's been a year. I found them guilty on May 11th, 2023. They don't have the courtesy to show up. I noticed in Sunbiz that the president is someone by the name of Jacob Ney or Ney Jacob. I can't tell what the first name or the last name is. There's also a Francis Jacob or a Jacob Francis, a vice president, secretary. I think they ought to be notified. Fixing a light fixture, unless there's something major with the electrical, should be a piece of cake. And why it hasn't been done, I don't know. You were going to say something. I'm sorry, I interrupted you.
I know you said they should be notified. Certified mailing did go out to them. I as well, when I was posting the property, Mr. Jacob was at the property. We had a not so friendly conversation. You know, I think most of us here at the city are very familiar with Mr. Jacob. He has several properties throughout the city, but he is fully aware of what's going on at this property.
I want to send the Jacobs a message that I'm not going to tolerate nonsense. We're here to do a job. We're here to protect the residents of the city of North Miami. Taking care of your property is a requirement under the code, and I'm not going to tolerate nonsense. And at least have the courage to show up when your property is cited for a violation. You may have a very good excuse. I'll listen to your excuse. I may grant you a little bit of time. I may table the case. But if you don't show up, I'm going to assume that you're showing disrespect to the special magistrate, to the city, and to all residents of North Miami. So based on the unrebutted testimony of the city's code compliance officer, the photographs and other evidence presented, that the property has been out of compliance since June 15, 2023. I find in favor of the city, hereby ratify the fines accrued to date in the amount of $250, plus a cost assessment of $100. The said fines shall continue to run on a daily basis until there is compliance. Let's hear case number 8.
Okay, case 8. And in case 8, as I'm calling this one, I'm going to ask the building official to also, you know, I know he's already logged on, but I might need you to give some testimony on these two, because I was out on vacation last week and had jury duty yesterday. So I'm seeing some emails that were sent to me regarding closing of this case, but, you know, different from our conversation via telephone call. So for this one, 1530 Northeast 130th Street, Shanna Sanders, Neighborhood Service Inspector, my apologies, for case number CEBPR 2022-00612 for the renewing of an expired window and paint permit. Magistrate, building official, are you familiar with this, and or do you recall sending me any emails about closing of this case? Because I'm showing this is a new case that I was going to present, but I'm showing you're saying close this. Is that correct? Building official, are you there? If not, I'm going to go ahead and move forward with presenting the case upon my last reinspection on the
Yes. Hello?
Yes, I'm presenting the case for 1530 Northeast 130th Street. for the renewing of those expired permits.
Okay.
I know we had a conversation via telephone call about me presenting these cases, but I'm seeing the email that you sent to me attached correlate to it saying, let's close this out. Please result the final inspection. Was that coming from you? Are you asking these cases to be closed?
Hold on. Let me, what's the address? 1530?
1530, yes. And I don't mind, let me go ahead and start presenting it, and then if you
Okay,
need to
no
close
problem.
it so that we don't, belay these hearings, we have a small agenda. Shanna Sanders, City of North Miami, Neighborhood Service Inspector. This case was originally cited for expired permits that I observed or looked on the computer when doing my annual housing inspection. We try to, check on everything, the aesthetics of the property, old violations, any and everything we try to inspect. Upon our inspection, I showed that they had some expired permits for windows that were installed, I believe, in 2020, along with a paint permit. I had a conversation with the property owner, Mr. Francis Jacob, along with his assistant, Liliana. They stated that they thought the permits were closed at that time. I informed them that it wasn't, and that they needed to call the city to pay the renewal fee and to get them closed out. At that time, I believe they said they did. As of my last reinspection on the 18th of June, the permit still remained expired, still remained in needing to be renewed, still remain outstanding. So I, unless the building official is objecting or saying something else that he would like to give testimony to, would like to go ahead and have these fines, not fines, I'm sorry, to have a guilty fine.
Adjudication.
Yes.
Yes, Mayor Jean, building official. And just as you presented this case, it came back to my recollection. So I did send that email at the last, towards the end of the special magistrate, but it came to find out there were some items on that was fraudulent. So we
You mean fraudulent?
Fraudulent, yes, for this case here. I remember this case, and actually I spoke to Liliana and kind of brought that to her attention regarding some documents we received. So these permits cannot be closed.
What was fraudulent about it?
Hold on. I think I notated the permit. Hold on. Give me one moment, Special Magistrate.
Yeah, take your time, Mr.
refresh
Building
you.
Official.
Yeah, I believe it was, just to kind of, help you out a little bit. Building official, I believe our conversation via telephone call was about the discrepancy with the contractor. The contractor stated, I think they were, if you want to, kind of jump in, something with the contractor was fraudulent.
So yeah, the contractor, actually I reached out to the contractor and he didn't authorize that for basically he didn't authorize, I believe his signature for that permit. So the permit was issued without his knowledge, and that was the issue with that.
You mean the original building permit?
Yeah, was not the contractor of records signature.
So that building permit expired?
Yes, and so basically the permit that was issued fraudulently for this case.
But whether it was issued fraudulently or not, whatever was filed, that expired in any event.
Okay, give me one moment. Actually, I have the actual files here. The windows, there's a stop work on those. There's a pending paint permit. Those were the two that
Yeah, so to answer your question,
Yeah.
Magistrate, yeah, they have expired. It seems from what I recall, when they called out to do the final reinspection, I believe, it was identified and brought to the attention that both the contractors for the outstanding permits weren't the contractors on file, and I'm, just, from what I recall and what was stated on, to me, they didn't do the inspection. They wouldn't pass the final inspections.
Special Magistrate, let me add. So I'm actually, I have the two files on my desk here. One's for a paint, one's for a window.
Window. And by the way, as you speak, Mr. Building Official, Ms. Sanders, show me pictures of the windows.
Okay. So the permit application that was received on the window, there's no date on the permit application, but this was notarized September 23rd, 2020. And the signature on here, the contractor they placed on here is James Nessum of JBN Construction. The signature is not the signature of the contractor, so that was forged. So I don't know if you can see it, Special Magistrate, there.
No, if you're telling me that it was forged and that was the testimony, or that was the statement of the contractor, then we're dealing with criminal behavior here on the part of whoever submitted those documents, and it gets worse here for the owner. So go ahead, finish your comments.
So the Special Magistrate, so at the end of the last hearing, I think when this was presented, I started to initiate closure of the permit, but when I dug deeper, we cannot close it. So that's kind of where we at, because of the signatures on the permit application submitted is not that of the contractor of record.
Okay, but did you have a chance, or did someone within your department have a chance to inspect those buildings for compliance with the county?
I believe there was a final inspection that was done for the windows, but the final inspection was done September 7th, 2022 by our building inspector, Ricardo Aller. But the fact remains that the permit was obtained fraudulently.
Okay.
So
So basically they need an after the fact building permit for the windows and the paint, right?
They need the permit to change the contractor, I guess. Aside from this, the criminal matter, they need to a change of contractor for those permits.
Yeah. Again, I'd like to ask the Assistant City Attorney to keep an eye on this, stay in the loop. We're dealing with potential criminal violations here in the signatures, the fraudulent submittal, forgeries, etc. But most importantly, we have windows here that may or may not comply, may or may not be consistent with product approvals and the county's processes. And here we are, almost a year later, and we still are in the same place. So,
Mr. Magistrate, if I may add, so the inspection was conducted, everything was okay with the inspection of the windows. It's just the process of the obtainment of the permit.
Okay, so the process, just to be sure, means that a new contractor needs to come in lieu of the one that was allegedly involved early on. Sure. That contractor then needs to file for an after-the-fact permit.
No, it could just be a matter of change of contractor. Basically, the new contractor would be on record and this permit, well.
Okay, would you, once that happens, would you need to reinspect, or that would be the end of it?
No reinspection could occur, but we still have to deal with the other matter.
Okay, this case has not been previously adjudicated, is that correct, Ms. Sanders?
That is correct.
Okay, so based on the unrebutted testimony of the city's code compliance officer, the photographs and the evidence presented depicting that the violations still exist, that proper notice has been given, I find in favor of the city, enter an adjudication and set a compliance date of, Madam Clerk, when is the next compliance date?
I'm gonna provide you with 3 magistrate, one, September 21st, October 19th, and November 16th.
September 21st,
Yes,
October 19th,
yes,
and,
November 16th.
okay, I am going to set a compliance date of September 21st. In the event of non-compliance, there shall be a daily fine of $1,000 until the violation is abated.
Magistrate, my
Yes,
apologies. What's the fine amount?
the fine amount is $1,000 per day.
Got it. Thank you. Yes.
All right. Are we done with 1530 Northeast 130th Street?
No, we have 3 more cases.
Okay, I
You're
guess
muted.
I guess they win the prize today for number of cases. Let's hear case number 9.
I'm sorry, I was muted. They telling me I was muted. I'm apologizing. Shannon Sanders, Neighborhood Service Inspector, case CELDR 2022-00019. This case is a new case. It was originally cited July 19th of 2022, whereas I was doing my my annual housing inspection for this apartment building, whereas I observed several violations. This one is in violation. I did it under the land development regulation for not having the proper driveway installed at a commercial building. If you look at the pictures, as you know, I'm sure the coordinator will show shortly, there is dirt and rugs out along the front inside of the apartment building that they're using as a driveway in our parking lot.
Yeah, I saw the carpets. It looks like a Turkish bazaar. Yeah.
Yes, I had a conversation with Mr. Jacob as well as Miss Liliana, and told her, explained to them that this did not meet the city's ordinance and regulations as to what driveways and parking areas are required. At the time of the conversation, he pointed at the neighbors next door and, was wanting to have more of a conversation about that than anything else. As of my last reinspection, a couple of the rugs, if not carpets, were removed, but some still remained. I explained to him, you need to pour down some rocks, put down some gravel, do something other than these carpets. As you will see, no one is here. I am showing proper service was given. I posted the property with a notice to appear on June 7th of 2023. Certified mailings were mailed out to the property owner as well as the listing agents. But as we see here, no one is here and the violation still remains.
I noticed some couches or chairs also on the driveway.
Yes, I mean, as you see, with these hearings, he has several violations, going on here. But yes, it's some outdoor seating that does not meet what patio furniture would consist of.
Yeah, in 30 years of government, I've never seen anything like this. People using carpets to as a driveway to park cars, and it's just unbelievable. And so, anything else you want me to consider?
Not in reference to this violation. I think that, the picture, says it all. The picture says it all.
I think you're maybe not you, but perhaps your predecessor had previously granted a 30-day extension.
Yes, we've given actually a few. We gave one for 30 days because they stated at that time they did not, they were not aware of the violations. Another one they gave, I think it was, I don't know if it was Easter or something to that effect. They asked for an extension. I think it fell on Passover or something to that effect. And now we have this one. They asked for another extension, but I believe I asked for it to be denied. I'm not sure. But I think Jose approved it. But they've asked for, they've asked for extension several times. So yeah. This is the one from.
I think that they've been jerking you around for enough times. So I'm going to set a compliance date on these particular violations based on the unrebutted testimony, the photographs and the evidence presented depicting that the violation still exists. Proper notice has been given. I find in favor of the city, enter an adjudication and set a compliance date of September 21. In the event of non-compliance, there shall be a daily fine of $1,000 until the violation is abated.
Next case, same address, Shanna Sanders, Neighborhood Service Inspector, property address 1530 Northeast 130th Street. This was in reference to violation under the annual housing inspection for the loose railings, loose faded railings that needs some proper repairs. Upon my initial inspection of the property, June 2022, we're doing my annual housing inspection. I observed some railings that seemed a little shaky along the base of the railings. They were rusted. They were, needing to be repaired. As you see here depicted in the pictures, it seemed like it almost it's disconnected to the flooring. It's kind of narrow at the bottom. Had a conversation with Mr. Jacob. It needed to be repaired. At that time, he stated he would, jump on the repairs. Upon my reinspection of the property when posting a notice to appear, he stated, honestly, Ms. Sanders, I forgot I have so many properties. Thanks for bringing this to my attention. I'll have it done by the reinspection. Upon my reinspection on June 20th, the property still remained out of compliance, and the railing still needed to be a little more secure, need to be repaired, painted, all of the above. As we're stating here, I'm showing in the pictures, they did ask for an extension. We denied one and then approved one. They have been talked to several times about, the different things that are going on with this property. But again, as of the last reinspection date, compliance has not been met.
Shameful conditions. They're horrible. It's a life safety issue. Somebody gets hurt, they're going to get sued. I hope they have insurance. The city cannot tolerate slumlords like that to operate in the city, and I'm going to make sure that we keep an eye on them. Based on the unrebutted testimony of the city's code compliance officer, the photographs and the evidence presented, depicting that the cited violation still exists. The proper notice has been given. I find in favor of the city. Enter adjudication and set a compliance date of September 21, 2023. In the event of non-compliance, there shall be a daily fine of $1,000 until the violations are abated.
And last but not least, this case, same property address, 1530 Northeast 130th Street, for CEMHS 2022-00477. While doing my annual housing inspection on June of 2022. Well, I'm showing here this. Oh no, no. This one I'm showing for some reason July. My initial inspection was July 19th of 2022, whereas I observed when I inspected the property, I observed that they had no identification placard. Per city ordinance, all commercial buildings and apartment buildings must have an identification placard showing who's the property manager, property owner, who should be contacted in the case of an emergency. I walked through the entire building, did not see anything of that nature posted. I, at that time, when posting notice to appear, had a conversation. Mr. Jacob was at the property, who is the property owner and listed as the manager and owner on Sunbiz as well, stated he did not know the placard was needed. I identified, informed him, yes, educated him on that. Again, the conversation was not so friendly. I pointed out, you have several properties here. But my last reinspection, placard still not posted at the property. They requested an extension, for which I denied. I told them that's not something that we should be even, conversing about a year later, So again, my last reinspection, compliance has not been met. I would like to move forward with having this adjudicated as well.
Yeah, this is such a simple violation to cure that it just shows total disregard for public safety. The reason we have these laws is that, number one, if one is a victim of a crime or one has an accident, the first thing you want to do when you call 911 is tell 911 where you are. The second reason, and if you don't have a street address posted in front of the property, that victim is unable to explain in many cases where exactly they are located. But even more importantly than that, when police, fire, rescue, other agencies need to visit the property for crimes or to serve a warrant or to look for a suspect, if the address is not shown, it can lead to potential problems. It's an easy one to cure, and why it hasn't been cured just goes to the total disregard for the public safety of this particular landlord. So based on the unrebutted testimony of the city's code compliance officer, the photograph and the evidence presented depicting that the cited violation still exists, proper notice has been given. I find in favor of the city and enter an adjudication and set a compliance date of September 21, 2023. In the event of non-compliance, there shall be a daily fine of $1,000 until the violation is abated.
Thank you, Mr. Special Magistrate.
Okay.
That's
All right.
the end for 30.
And Madam City Attorney, you do what you have to do to, legally enforce any orders that I may enter and advise the people involved that we're not playing games.
Will do.
This magistrate is not going to put up with this type of neglect. I just want the public to know that, that we're doing everything we can to keep the city safe. Anyway, let's move on.
Magistrate, we have one attendee that showed up, and I'm going to go ahead and call her case, which is Amanda Roden. She is here for item number 25 and 26, which is Klaus House LLC. Case number for item number 25 is CEFOB 20210007. This case was previously found guilty with an abatement date of February 4th, 2022. Fine set at $350. And item number 26, case number is CEZCU 20210092. This case was also previously found guilty with an abatement date of February 4, 2022. Fine was set at $350, and the officer is Jonathan Lemestri.
Okay, let's hear the BTR case number the 25. Who's here on behalf of Klaus House LLC?
Amanda, please raise your right hand.
Hi, yes, my name is Amanda. I am representing Tria Tesla, which is the business running out of Klaus House LLC, the owner of address 1290 Northeast 125th Street.
Amanda, please raise your right hand.
My hand? Here.
Yes.
And
I'm gonna swear you in.
okay.
You gotta be sworn.
Do you solemnly swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth? So help you God. Please say I do.
I do.
Ms. Roden, apparently you represent one of multiple businesses at that address, 12450 Northeast 13th Avenue.
Yes, I run Tria Tesla, which is a leasing
You run what?
Tria Tesla,
Okay.
which is a leasing consulting business out of Klaus House. Klaus House is the LLC of the owner of the 1290 address building.
All right, but you're not here representing Klaus House.
No, we were a little bit confused of how this worked actually, because Klaus House and Tria Tesla, they're both the same owner. So Klaus House is the owner of the building, but Tria Tesla is running out of that building. So we're currently in the process of getting the certificate of use for Tria Tesla out of 1290.
Okay, we're not at the certificate of use case yet. We're at the business tax receipt. Do you understand that there has already been a guilty finding on Klaus House for failing to have business tax receipts on multiple businesses at that address? Do you understand that an order has already been issued?
Yes, that's the letter that we received. But what I was told is that we just had to apply for the certificate of use for Tria Tesla.
All right, I'm a little bit confused, so I'm going to ask the city to explain to me the nature of this violation. And the business tax receipt is usually easily obtained. It's usually the certificate of use that creates a problem. And so can I get information on what's going on with this property, both for its tenants and for the property owner?
Yes, Magistrate Smith. Good morning, everybody. Neighborhood Services Inspector Jonathan Lemestri. And this case, we'll start with the business tax receipt, CFOB 2021-0007. So yes, there are multiple businesses at this location. I have Cyberplace LLC, Tria Tesla, Klaus House LLC, Robotaxi Miami Inc., and Klaus Parking System Atlantic Inc. On Sunbiz, I do have Klaus Parking System Atlantic Inc. Inactive, and also Robotaxi Miami Inc. So the only three businesses at that location at the moment is Cyberplace LLC, Klaus House LLC, and Tria Tesla Inc. Tria Tesla LLC. As of the final reinspection date of June 20th of this year, They have not obtained their business tax receipt and or their certificate of use. I did receive an email from zoning last week from the zoning clerk from the city of North Miami, and they informed me that they're waiting a DERM approval for their certificate of use for Try a Tesla. And that's where we're at the moment.
May I say something?
Yeah, one second. You have more pictures to show me?
So they do have a rental business running out of this location where you could rent a Tesla from this location. So, if you wanted to rent a vehicle from Try Tesla, you can from that location. I believe if you go all the way to the bottom, Edme, there should be a placard. Yes. So that's the list of their businesses that's running from that location. Again, at the moment, we only have 3. Again, this case is old. This case is from July 2021. But at the moment, we have Cyberplace LLC, Claus House LLC, and Try Tesla running.
All right, leave that picture on the screen for just a minute. I believe I recall, correct me if I'm wrong, that the zoning issue had to do with parking vehicles outside of the premises in violation of zoning. Isn't that the main reason they haven't gotten their BTR and their certificate of use?
I recall that as well. They had a zoning inspection and it was denied by the zoning inspector because of the multiple vehicles that were parked at the location.
Okay, so how do they get a certificate of use if they can't put the vehicles anywhere else? Can they put them inside and would that cure the violation?
That I don't have the answer to that. That would be zoning that could probably answer that question.
Okay, so what's pending with zoning now?
So yes, I did receive an email last week from the zoning clerk stating that the party, Claus House LLC, came in and they're just waiting for DERM approval. And they need to get more time in regards to get approval from DERM in order to continue with the process to get their certificate of use.
Well, they can get 50 approvals from DERM, but if the planning and zoning department says it ain't happening, we're going to be back to square one. So how do they deal with the planning issue, zoning issue?
Well, they would have to.
May I say something?
In a minute, I'll ask you. I'll let you speak.
Well, they would have to remove the vehicles from the parking lot.
Okay.
They would have to remove the vehicles.
All right, Ms. Roden, let's get
Yes.
let's get to the bottom line.
Okay.
Where is this going to end up?
So I wanted to give you an update of what we've done to correct this issue. So right now, all of the RoboTaxi and all of the other ones that were listed that are inactive, we sent a letter to cancel the business rates for those businesses. Also, there's no more renting out of this location. The cars that you may see in the lot are for our employee use only. We don't have anyone coming to our location anymore to rent the vehicles. Also, yesterday, DERM Fire approved this, the certificate of use in Miami-Dade County. And I went straight to North Miami to give all of the paperwork to start the process with North Miami for the certificate of use.
And you're confident that you're going to be able to get the certificate of use from zoning?
Well, I believe so, yes, now that we're compliant and we're doing the things correctly. Since there's no more renting, the parking lot is only for our employees. Myself have a Tesla, by my dad. So, we're not renting. Those cars that you see in the lot, they're all for employees.
So how do you rent your Teslas?
Right now, we're actually just doing leasing and a consulting leasing for long term. So if we do have a person that wants a car, then we deliver it to their location.
So customers do not come to your location to lease
No.
Teslas?
No, no.
Okay, you understand that that would violate zoning, right?
Right. That's why we decided that we're not gonna do it, and as well as other reasons, but you know, we understand that that wasn't allowed here.
Okay, have you shared the DERM permit with the city?
Yes, I took it yesterday and I met with the front desk clerk. I turned in all of the paperwork, the DERM approval, fire inspection, the $125 check, and the application, everything else, the lease agreement for Try a Tesla.
Okay, and as part of the process, are you also providing the certificate of use application to the Planning and Zoning Department?
Right, the application was also stamped. There was a stamp that was needed for DERM that I went back and did that during that process. So I
Okay.
turned in there.
So that's pending then?
Right, as of yesterday. As soon as I got the DERM approval
Okay.
yesterday, I went to
Okay.
the North Miami.
Okay, I'm gonna table both cases until my next special magistrate hearing and see how this all turns out. But please do not disappoint me in
No.
trying to get around the zoning issue by, you know, leasing out of the premises, which is not allowed.
Right.
And using whatever permitted parking spaces you have for people who are working there. And of course, you need to convince the planning and zoning people that you have the permitted number of parking spaces allowed. So if you lack spaces, then you got to deal with that. I'd like to get a zoning approval, hopefully by the time that we meet again. So I'm going to table this, considering your good faith actions, and I'd like to see full compliance and remove, by the way, remove the names of those entities that now no longer exist. And
We currently we have the sign, that silver sign. It's off.
okay, and once you get your zoning and DERM permits, then you need to obtain the certificate of use, and then I'll hopefully at the next time I see, hopefully I won't see you. Hopefully the violations will go away. The inspector will determine whether or not there is compliance. If there is no compliance, then the case will come back to me, and I will ratify the fines, and that's going to cost you a lot of money. It's going to be expensive. So you need to really move quickly on this, because time flies, and you know, you got some things, some homework to do. So that's going to be my ruling.
What else? May I ask what else is pending? So
please,
as soon as I get the certificate,
speak to the code officer and keep him informed on what it is that you're doing.
And Magistrate and Amanda, just to advise you guys, the next hearing is for September 7th.
Okay, so if you're not in compliance, it'll come back to me on September 7th, and I promise you that I will ratify all the fines which were ordered back in November. Was it that far back? November 21, November 18th of 2021.
Yep.
Wow.
They had until February 4th of 2022.
Abatement was supposed to be by February 22. I got to tell you, that's a lot of money if you don't come into compliance by the next hearing. So
Okay.
Move
I
quickly.
appreciate it, and thank you for allowing us to fix the problem.
Whatever you need to do, it's going to cost you a lot less than the fines will. So please
Right.
move on it. All right, next case, that covers both the business tax receipt and the certificate of use. Next case.
Thank you.
Thank you.
Magistrate, we're gonna proceed with item number 12, which is 640 Northeast 128th Street LLC. Case number is FYBRR 2016-00015. And Mayor Jean will be presenting this case.
Yes, Mayor Jean, building official. This case is regarding the 40-year recertification that's outstanding. The owner was property service, and as of the last conversation I had with Albert Mendez, sorry, I said Menendez. Albert Mendez was around June 20th, and I expressed to him. Also, we talked on the phone, and I followed up with an email. I expressed to him that please provide, even though the building is under construction. I believe he has a permit that was issued for that building. I told him, even though the building is under construction, please provide us a 40-year recertification report. That even though it states that it's under construction, that we can take that in. So that's kind of where it's at. But I haven't seen a 40-year recertification submitted to the building department. Also, he submitted it was a unsigned letter stating that the property was under construction. So, but I told him that's not sufficient to please provide us the.
Okay, let me see if we can get the semantics right.
Hmm.
There was an old building there that is over 40 years old that is being renovated. Is that
correct?
Okay. So there are two issues. There's the fact that it's at least a 40-year-old building that needs the 40-year recertification.
Correct.
And also separately, he's got renovation permits and what have you going on at the same time. And the owner's position was, well, since we're renovating it, why do I need a 40-year recertification? And the simple answer, and you can correct me if I'm wrong, is that you got a 40-year-old building. And the law says if you've got a 40-year-old building, you got to file for a recertification, right?
Yes, correct. All buildings 40 year, well, previously 40 year and older, now it changed to 30 year and older.
Yeah, I understand. But this one is a 40-year.
And also, his other argument was that the building was not occupied. But in the past, with an unoccupied building, I mentioned to the other case that I had, just to submit, I'll give you whatever time you need, but just provide me a report so that way we know the state of the building.
And he hasn't done that.
He has not.
Okay. Well, if he disagrees with your interpretation of the 40-year recertification rule, then all he has to do is file an appeal before the board, the Board of Rules and Appeals. Correct.
Correct.
He hasn't done that.
He hasn't submitted. No, he hasn't gone through the appeal process.
Okay, so your ruling is my ruling, is that he is in violation of the 40-year recertification county ordinance. So I'm going to find that based on on your unrebutted testimony, the photographs and the evidence presented depicting that the violation still exists, proper notice has been given. I find in favor of the city, enter an adjudication and set a compliance date of September 21, 2023. In the event of non-compliance, there shall be a daily fine of $500 until the violation is abated.
Okay.
All right. I noticed, by the way, that the matter had been tabled previously from November of 22 to April of 23. Is that correct?
Don't have that history in front of me, but when it was presented to me again, I told let's go ahead and hear it. So that.
Yeah, well, I did review the file, and I did find in the file that the matter had previously been tabled. So the owner has had plenty of time to comply with the 40-year recertification ordinance. All right, let's move on to the next case.
Item number 13 and 14, we have 690 Northeast 133rd Street LLC. Case number is MHVIO 2022-00565. And item number 14, case number is MHVIO 2022-00569. And the officer is Jonathan Lemestre.
Yes. Good morning, everybody. Neighborhood Inspector Jonathan Lemestre, and this case is being heard for the first time. On August 31st, 2022, an annual housing inspection took place at 690 Northeast 133rd Street. This case is in regard to extermination/fumigation report. As of the final reinspection date of June 20th, 2023, compliance hasn't been met. The property owner has not reached out to me to provide me with an extermination report for the property, for the multifamily property. And if you could see from the pictures, we mailed the registered agent and the property owner from Property Appraiser.
Okay, I'm showing 3 property owners or 3 managers on this LLC: Abraham Ebenstein, Todd Stock, and Samuel Ebenstein as managers of the LLC. Again, I encourage the city to write to those individuals directly. I don't look kindly on people who are the subject of violations not showing up and explaining what the problem is. I am going to fine in favor of the city based on the unrebutted testimony of the code compliance officer, finding that the violation still exists, proper notice has been given. And I will enter an adjudication and set a compliance date of September 21, 2023. In the event of non-compliance, there shall be a daily fine of $500 until the violation is abated.
Yes, sir. Thank you.
The next one is on the same property, and it's for lack of posting of contact information.
Yes, sir. Same property. The violation is just for them to post a case of emergency contact information at the property, and as of the final reinspection, there's nothing posted at the property.
All right. Based on the unrebutted testimony of the city's code compliance officer and the evidence presented depicting that the site violation still exists, proper notice has been given, I find in favor of the city, enter an adjudication and set a compliance date of September 21, 2023. In the event of non-compliance, there shall be a daily fine of $500 until the violation is abated.
Thank you.
Item number 15, we have A&B Staffing Group LLC. Case number is CEGEF 2022-00021. This case was previously found guilty with an abatement date of June 15th, 2023. Case fine was set at $500 plus $100 cost assessment, and the officer is Christopher Colson.
Good afternoon. Good morning. This is an old case. My name is Officer Colson, City of North Miami, Neighborhood Service Department. This case was, as I stated, this case was previously heard before. We found him guilty. The case was originally opened on 5/25/2022. Properly mailed and notified. All properties have spoken with people on the property before. Still nobody has resolved the issue, and as of final reinspection that took place on 6/20/2023, the violation still remains.
Please show me the photographs of the dumpster. dumpster enclosure. There it is. So that is the dumpster. Now, the code requires that there be an enclosure so that that's not visible.
Yes.
Okay. Is that the only picture you have?
That's probably the most recent pictures. Probably
Okay.
other was in there.
Okay. And they would need to pull permits to build the enclosure, correct?
Yes.
And
Yes.
of course, they have to provide a dumpster for the tenants to be able to dump the garbage.
Yes.
All right. And I've previously found the owner guilty
Yes, you have.
on May 11th, 2023, with an abatement date of June 15th, 2023. I had set a fine amount of $500. Based on the unrebutted testimony of the city's code enforcement officer, the photographs and other evidence presented, reflecting that the property has been out of compliance since June 15, 2023. I find in favor of the city, hereby ratify the fines accrued to date in the amount of $500 per day, and assess costs in favor of the city, authorize the entry of a lien. This said fines shall continue to run on a daily basis until there is compliance.
Thank you, Your
Next,
Honor.
please. Yeah, by the way, the names on the LLC on Sunbiz is Daniel McCanner and Jared Linden. Be good to let them know that they're being hit with $500 a day fines.
Magistrate, I'm going to call item number 16 through 20. Item number 16 is ND Predulis. Case number for item number 16 is CEEXC 2022-00015. This case was previously found guilty with an abatement date of June 15th, 2023. Fine was set at $500 plus $100 cost assessment. And item number 17, case number is CEFOB 2022-00349. Item number 18, case number is CEGAB 2022-00002. This case was previously found guilty with an abatement date of May 18th, 2023. Fine set at $350 plus $100 cost assessment. Item number 19, case number is CEMHS 2022-00417. This case was previously found guilty with an abatement date of June 15th, 2023. Fine set at $500 plus $100 cost assessment. And item number 20, case number is CEZCU 2022-00634. And the officer is Shanna Sanders.
All right, Ms. Sanders, we're not going to spend a lot of time going over each one of these cases since they were all previously adjudicated guilty. I just need you to quickly run through them. And as the first one, number 16, show me the condition of the wall, soffits, fascia, the mold, the mildew, the peeling, the cracks, all slum-like conditions.
Special Magistrate, Neighborhood Service Inspector Shanna Sanders, as you're showing here, as is shown in the pictures depicted, soffits and roofing area that has fallen apart. It is flaking. It is crusted, mold, mildew, cracks throughout the entire building.
This is a single-family home or a multi-family home?
This is a multi-family unit. I believe it's like it's either 6 to 8 units. It's a small apartment building.
Are there people living there?
Yes. Out of, I believe it was 6, I believe only 1 was not occupied. And at the time of my reinspection, actually he said he had someone that was moving in July 1st and he had a handyman there that was cleaning it out, but it is occupied.
Well,
and the owner lives in one of the units. I think he lives in unit 1.
yeah, quite frankly, it looks like a slum. So Based on the unrebutted testimony of the city's code enforcement officer, the photographs and other evidence presented reflecting that the property has been out of compliance since June 15, 2023, I find in favor of the city, hereby ratify the fines accrued to date in the amount of $500 per day and assess costs in favor of the city. The said fine shall continue to run on a daily basis until there's full compliance. Let's move on to number 17.
Number 17, this one is, I just want to make sure I'm looking. This one is actually a new case, so I'll, speak a little more on this one. For failure
Business
to
tax receipt.
exactly kind of open and shut upon my initial inspection of doing an annual housing inspection May 12th of 2022, walked throughout the entire unit, observed several violations on this property. At the time of the inspection, the property owner came outside of his unit, walked the property with me. He was educated and informed at that time that he needed to obtain a business tax receipt. He stated that he had attempted to apply for the business tax receipt as well as the certificate of use, which is another case coming up. However, due to all of the violations and problems going on with the property, he was not even able to submit an application. He was told that the property needs to be brought into compliance and looking and being in livable conditions before he can even submit an application. As of my last reinspection, the property still remains out of compliance. He has not been able to apply for the certificate of use nor business tax receipt because, as you saw in the pictures before, ceiling falling apart. It needs the building needs permitting and needs some repairs made. So proper service was given. I hand delivered the notice to appear to the property owner. So he is aware of the violation, but as of my last reinspection on the 20th of June, compliance has not been met.
And I noticed that Magistrate Casal tabled the matter previously, correct?
Yes, because at that time, I believe the first one, it was, he stated at that time he had just got robbed by Handpoint. He was asking for leniency at that time. He stated because he was trying to get all of these other things taken care of, could we give him a little bit more time? So the magistrate did table this along with the certificate of use and I believe the placard violation because they were small and stuff, and again he couldn't do anything without rectifying the other situations at first. However, now we have moved on. I think 2 or 3 months later, the building still remains in need of repairs. And as I explained to him, something needs to be done. We can't just continue to table these cases without movement being made. So, here we are today with those cases that were not heard from, I believe, again, I don't remember which hearing, but a couple of hearings back.
Yeah, I agree with you. I think it's time to move this along quicker. Yes, he won't be able to get a business tax receipt until he fixes all the other problems, but this will encourage him to move along a little quicker. Based on the, and this is a new business tax receipt issue is a new one, right?
Yes, this one, and if I'll be bold enough to say this one and the certificate of use, they kind of run hand in hand, so we could probably do both of those together. So yes, that one and.
All right. Okay, I'm gonna, my ruling is the same on both the certificate of use and the business tax receipt, so I won't have to repeat myself, okay?
Okay.
Based on the unrebutted testimony of the city's code compliance officer, the evidence presented depicting that the violation still exists, proper notice has been given. I find in favor of the city, enter adjudication, set a compliance date of September 21, 2023. In the event of non-compliance, there shall be a daily fine of $500 until the violation is abated. That goes as to case number 17 and case number 20. All right.
Okay.
What
Okay.
else you got?
Next case is 18, same property address 780 Northeast 127th Street. This one was cited under Chapter 9 in reference to garbage, not having the proper garbage service with the city. Upon my initial inspection, doing the property annual housing inspection, notice a property that did not have a dumpster. By city code, all commercial properties need to have some type of service as to how they discard of their trash. Had a conversation with him. We don't have to hear the case all over again because I'm looking here. This was already adjudicated as of my last reinspection on June 16th of 2023. Compliance has not been met. The garbage enclosure still remains there, but no dumpster.
So how do people get rid of their garbage? They just dump them in that little shed?
To be honest with you, and we had this conversation at the previous hearing, and I don't mind saying it on record again, actually they discard their trash at the neighbor's property, which I told him, then becomes another violation. The city's code is very clear on that the garbage needs to come from the property in which the garbage is produced from and at. But as I told him, you got a lot going on here. We can address that a little bit later. Let's see what we could do about, possibly getting a dumpster, even if a small 4-footer. Even if I told him, beg and plead to Waste Pro, maybe see if they'll give you 2 96-gallon containers, but I believe he called and he had an outstanding balance with them, so they weren't able and willing to really do any of that stuff until he gets that outstanding balance paid down. So they discard their stuff next door.
So does the city require that the property owners in general do business with a pre-approved set of garbage disposal companies, or you can just hire anybody you want?
No, it changed, a few years ago in Chapter 9, and it clearly states it has to be a, pre-approved company that the city, has contract with, if not for better words. So it's a very small list, if not, I don't want to put out any names, but, very small list on who they need to have services with.
Okay, so when Magistrate Casal tabled the case at the time that you heard it, what was the property owner asked to do? To get a dumpster?
He was asked to get services with the dumpster contract company.
And that hasn't been done as of today?
No.
Okay. So based on the unrebutted testimony of the city's code compliance officer, the photographs and the evidence presented depicting that the cited violation still exists, proper notice has been given. I find in favor of the city, enter an adjudication and set a compliance date of September. No, I'm sorry. I'm reading. This is adjudicated previously. So what I'm going to do is I'm going to ratify the fines. This is not a new case, unlike the last one. So based on the unrebutted testimony of the city's code compliance officer, photographs and other evidence presented depicting that the property has been out of compliance since May 18, 2023, I find in favor of the city and hereby ratify the fines accrued to date in the amount of $350 per day plus $100 cost assessment. Authorize the city to impose a lien on the property for these fines and costs. The fines shall continue to run until there is compliance. We got one more involving the same property. This one, 19.
Yeah, this one, case number CEMHS 2020-417. It seems, very much in comparison to the initial one, but this one is actually for the cracks and stuff or whatever throughout the walls. The first one is for the soffits in the ceiling area. This one is, kind of around the same thing. The walls of the property needs to be repaired, has cracks and things throughout. As of my last reinspection on, I'm showing here, June 16, 2023, compliance has not been met. I had a conversation with the property owner. He says he has someone working on it. I believe, and let me kind of look and see, because I think he submitted an application for some repairs. He has some place for some repairs, but the walls and everything still, the permit still needs to be obtained for those repairs to be made. I just want to look to see to make sure. Oh no, that's for the conversion of the breaker box. So yeah, that one, compliance has not been met as of June 16th of 2020. The cracks still remain throughout the units, throughout the walls, ceilings, everything.
My problem with this one is that it seems to be covered by the
first one.
The first one, which it does talk about cracks.
Yeah,
But-
and with this one, I'm willing to close this one because I'm kind of looking, and I'll be honest enough to say I thought kind of like you. I was like, and he already has a lot going on there. I moved it forward only because it was already adjudicated, but I'm really okay with closing this out.
Because it's part of
It was
number
the code
16.
section.
It's part of number 16, because it does say cracks. They both say cracks.
Yeah, so this one I'll close. I just wanted to look and see what code section I cited it under, but yeah, that EXC can fall under the same umbrella.
You cited 12-20 A, I believe.
Yeah, so this one, let's mark it as abated. I'll close this one out before the end of the day.
Yeah.
But this one it was cited under 5-19, which also requires them to
nuisance.
paint
Yeah, but it's
the
the
building.
same. It's the same violation. So you pick or choose whichever violation. Number 16 and that different. I don't know. I just feel like citing him twice for the same violation doesn't seem fair.
With section I cited the other one for offhand.
Number 16. Give me 1 second.
16 was
I have so many open things.
12-20.
So it's kind of the same thing. Both of them under, yeah. So we can. Let me look at the wording of it. Severely cracked fascia. Let's close this one because at least the other one includes the walls, fascia boards, soffits, cracks, and paint, peeling paint and stuff throughout the building. So I would prefer to leave the the EXC one open and close this MSHS one.
Yeah,
So let's close this
I
one.
think that's a good thing, and if it turns out later that you need to bring it back under a different code section, if that's what you decide to do later, you can do it. But I think it's covered by 16 already. So let's move on to the next one.
Okay,
which
so
I believe it's 20, right?
and we heard 20 that's one for the certificate of use.
Oh,
We heard
was
that one with
certificate
the
of use. So we've already covered that. Did we provided an abatement date on both the certificate of use and the business tax receipt, right?
yes, I think we gave September 23rd.
21.
Okay, 21st.
21.
Let me write that down.
Yeah.
Okay. Switch close.
Okay. I
Thank
think
you.
we're done with that customer.
Yes. I'm
All
gonna
right.
call. We're gonna move forward with item number 21 and 22. Biscayne Investment Properties, case number CEFOB 2022-00139. This case was previously found guilty with an abatement date of November 4th, 2022. Fine was set at $250 plus $100 cost assessment. And as for item number 22, same property owner, case number CEZCU 2022-00285. Previously found guilty with an abatement date of November 4, 2022. Fine set at $250 plus $100 cost assessment, and the officer is Jonathan Lemestre.
Good.
Hi there. So just to cut to the chase,
Yes, sir.
we have a beauty salon
Yes.
Doing cosmetology. They've been there 3 or 4 years. They don't have a business tax receipt. They don't have a certificate of use. The business name is Pink Vanity Company, LLC.
Yes, sir.
But you're not citing Pink Vanity, you're citing the property owner, correct?
Yes, the business is at a strip mall, and I'm citing the property owner because the property owner is responsible for their tenants at their property.
Okay. And they both, both cases are subject to a prior adjudication, right?
Yes, sir. They were found guilty back on November 4th, 2022.
By me.
By Magistrate Smith. Yes, sir.
Okay. All right. So based on the unrebutted testimony of the city's code compliance officer, the photographs and other evidence presented showing that the property has been out of compliance since the abatement date of November 4th, I hereby find in favor of the city and ratify the fines accrued to date in the amount of $250 and assess costs in favor of the city, authorize the entry of a lien. Fines shall continue to run on a daily basis until there is compliance. I'm going to issue a similar ruling regarding the next case, right, which is the certificate of use, correct? Certificate of use?
Yes.
Yes, sir.
Based on the testimony of the city's code compliance officer, the evidence presented showing that the property has been out of compliance since November 4th, 2022, I find in favor of the city, hereby ratify the fines accrued to date of $250 per day and assess costs in the amount of $100 in favor of the city. The fines shall continue to run on a daily basis until there is compliance. City is authorized to file a lien.
Thank you.
And we've previously dismissed number 23. Are we now down to 24?
Yes, we are. Item number
Okay.
24, JC 125th Street LLC. Case number is MHVIO 2022-00459. This case was previously found guilty with an abatement date of June 15th, 2023. Fine was set at $250 plus $100 cost assessment.
Okay. Is it Mr. Murillo?
Yes.
Okay. Now, I just want to know if any efforts, any actions have been taken to obtain an after-the-fact building permit for the dumpster enclosure.
Murillo?
Do we
Yes.
have anybody on that case?
Yes, he's here.
You guys hear me?
Yes, now we do.
Good afternoon.
State your
Inspector
name and position for the record.
Yes, Inspector Murillo, Neighborhood Services Department. This case is gonna be heard for the second time. Again, this violation was observed on July 20, 2022. And it was for the property address 447 Northeast 125th Street. They're required to obtain an after-the-fact permit for the newly built dumpster enclosure. I assure that proper service was given. An order to comply was posted on May 2nd, 2023. A notice to appear was posted on June 6, 2023. And as of my final reinspection, June 15, 2023, there was no compliance.
Since my order of April 4th, 2023, have they done anything?
Well, let me check.
Have they at least gone?
Yes,
to
they applied for the permit, but it has been denied for the building department.
Do you know why?
There was a note here that says they show setback dimension of dumpster enclosure. Provide notes on plan that state that part of the enclosure was beyond the property line, but they haven't done anything after that.
All right. It's not helpful that they're not here to
No.
maybe ask for more time or explain what they've done or haven't done. Based on the unrebutted testimony of the city's code compliance officer, the photographs and other evidence presented, showing that the property has been out of compliance since June 15, 2023, I hereby find in favor of the city and ratify the fines accrued to date in the amount of $250 plus a $100 cost assessment. The fine shall continue to run on a daily basis until there is compliance, and I authorize the filing of a lien against the property.
Item number 27 and 28, we have La Puerta Life Center, Inc. Case number is CEFOB 2022-00158. This case was found guilty with an abatement date of March 16, 2023. Fine set at $500 plus $100 cost assessment. And as for item number 28, case number is CEZCU 2022-00306. This case was previously found guilty with an abatement date of March 16, 2023. Fine set at $500 plus $100 cost assessment. We have Shanna Sanders.
Ms. Sanders, can you inform me of anything that the property owner has done since my, no, this was Magistrate Gazal, since her order of 11 November of 2022?
Shanna Sanders, Neighborhood Service Inspector, Neighborhood Services Department. Compliance has not been met for neither one, for neither the business tax receipt nor certificate of use. As of my last reinspection on June 15th, I know he was instructed to apply for the permits, apply for the certificate of use and business tax receipt, but upon my last looking in the computer, that still has not been done.
Is this a like a healthcare center, medical center?
It's actually a church. I know the building official has had, quite a bit of contact with him. I'm not sure what his latest conversations was with Mr. Jean, but I know he had applied for the certificate of use. However, the structure, when they went to do the inspection, the building of not the church has been gutted out. And they needed to pull some permits and do some things interiorly to the building before he could move forward with the next step for the certificate of use. I don't know what, if he's done anything internally building wise, but, I've only dealt with the certificate of use and business tax receipt violations. So, but
all right. So if they're not engaged in any business or religious activity, would they need a business tax receipt and a certificate of use?
And that's, if you look like at the history, that's why we tabled it and went back and forth so many times, because that was the question or concern, especially because the sign is still up there. And, we've had conversations on, if you're not using it at this present time, possibly take the sign down, maybe it off of Sunbiz, I don't know, but we've had those conversations. But because the sign is still there, because he still wants to keep it, hoping that he'll get the permits eventually and things of that nature, the city stance kind of was, if I remember correctly, how would we know if he's not having service or not, especially because just looking at the building on the outside, we would assume that it's running. We're looking in Sunbiz, it still shows as a running business. So that's why we as a city decided to keep the violation and move forward, because, all things taken into consideration, we wouldn't know if there's services being held there or not.
Okay, I hear you. So based on the unrebutted testimony of the city's code enforcement officer and the evidence presented reflecting that the property is out of compliance, has been out of compliance since March 16, 2023, I find in favor of the city and hereby ratify the fines accrued to date in the amount of $500 plus $100 cost assessment. The fine shall continue to run on a daily basis until there is compliance. As to the certificate of use case number 28, same ruling based on the testimony of the city's code compliance officer, the evidence presented showing that the property has been out of compliance since March 16, 2023. I find in favor of the city and hereby ratify the fines accrued to date in the amount of $500 and assess costs in favor of the city. The said fine shall continue to run on a daily basis until there is compliance.
Thank you. Mr. Jean, were you about to say something? Did you want to put something on record? I think I heard you talking right before the bill, before the magistrate started saying something.
Yes, no, Mr. Magistrate, and I should have said this before you ruled. I mean, I have been in contact with him, and he expressed that, because of after COVID, the church kind of fell on some hard times with membership. So he said they're holding services at a school. I guess I don't know what school, but an auditorium of a school, and they're not holding services there at the present location.
Well, what about some of the other things that the code officer mentioned, like having a sign, being licensed, and having their registration with Tallahassee? I don't want to hit the church with violations if they're not correct and fair, but the building is still open for business.
Has he moved forward, Mark, with any of the building stuff that needed to be done? I remember you speaking on testimony, giving some kind of insight to work that needs to be inside the building. Has those permits been obtained?
The item that he's provided to me was the 40-year recertification. So we have that now. That's the only thing that the last thing he submitted to me.
How long ago was that?
That might have been a couple of months back.
Okay, so yeah, we can let this stand, and if compliance isn't met at a later date, he can always, ask for the fines to be released, reduced, mitigated later on. But yeah, okay.
Yeah, there may be another way if he comes back at the next hearing and asks that I vacate the order because it was entered, improperly. I'll entertain, or maybe a status report. I'll keep jurisdiction of the case if they can come back and prove to me that they are not doing any business at the premises and that they're moving forward with plans for renovation. But as it stands right now, especially since, look, they could have come here. And I encourage people when they have issues like this to come before me and explain to me what's going on. But the fact that they good at that, the fact that they show disrespect to the city, to the residents by not even appearing, I'm going to let this stand unless I'm convinced that my order is in error, or they can show good cause for me to set it aside. So let's just leave it at that.
Okay.
Thank you.
Mm-hmm.
We're gonna call item number 30, Noyd Francois, case number CEBPR 2022-00620. This case was previously found guilty with an abatement date of June 15, 2023. Fine set at $500 plus $100 cost assessment, and the officer's Christopher Colson.
Mr. Colson, just to save time, just put on the screen the photographs. I've reviewed the file. I'm familiar with it. I issued the order finding the property owner guilty. Very quickly, just show me the photographs of the metal panel, the was built, the fence, the metal panel fence.
There's the photographs now up of the metal panel fence. And it's still as a final reinspection, there's no permit on file for the fence.
Any communications with the property owner?
No, I left notices. I went by there one day. It was teenagers out playing. I spoke with them, but it still left a card, no answer back.
All right, I don't see any photographs yet.
We went past them. Right there, they're up on the screen now.
You're clicking on it, but I'm just seeing a lot of recommendations and notifications. I see it on the side, but it very little, very small picture.
How about now?
Nope.
No? Hold on. Give me 1 second.
Yeah, because it's showing on our screen, Edme.
How about now, Your Honor? Because she enlarged it.
Yeah, I can see it behind the other panels, but I'm familiar. I just wanted the public and I wanted everyone to see what we're talking about. I have seen the permit, the fence rather. So based on the unrebutted testimony of the city's code compliance officer, the photographs and other evidence presented depicting that the property has been out of compliance since June 15, 2023. I find in favor of the city and hereby ratify the fines accrued to date in the amount of $500 plus a $100 cost assessment. The fine shall continue to run on a daily basis until there's compliance. That takes care of number 30.
Item number 31, North Miami West Holdings, LLC. Case number is CEZCU 2022-00449. This case was previously found guilty with an abatement date of March 16, 2023. Fine set at $250 plus a $100 cost assessment, and the officer is Gennaro Murillo.
Mr. Murillo, tell me again why they don't have a certificate of use.
Well,
there's something on my screen which doesn't let me see anything.
okay, so first they didn't have any licenses, right? So after right, they were notified of the violation and everything. The last email I received from Ms. Liliana, it was that they originally submitted all documents to the city on August 23rd, 2020. Well, she said 2021, and it was until this year that the city requested them all the documents. She said that they already received all the approval from Durham, and they were resubmitting all the documents to the city. But this was on March 16, 2023. After that, I haven't heard nothing from them.
What is it that they want to do?
Excuse me?
What business activity do
this
they
is
want
this is a multifamily.
A what?
This is a multifamily.
Okay.
This is an apartment building.
It's another property of Francis Jacob, magistrate.
Or certificate.
Yeah, I see that he's a registered agent. And there's some other Jacobs as managers. There are multiple applications on file. I couldn't understand why they file so many applications.
What you mean, John?
Well,
they
file more than one application to the Planning and Zoning Department.
You mean from the same property?
Yeah.
Oh, I don't know. They just said that that the city requested them a couple of documents, and they were resubmitting everything, the complete package, to the city on March, and I haven't seen the certificate of use of the BTR on our system.
Okay. You're not citing them for a BTR violation, are you?
No, I don't have that. No, it's for the certificate of use.
Of usage. All right. Based on the unrebutted testimony of the city's code enforcement officer and the evidence presented depicting that the property has been out of compliance since March 16, 2023, I find in favor of the city, hereby ratify the fines accrued to date in the amount of $250 plus a $100 cost assessment. The fine shall continue to run on a daily basis until there's compliance.
Thank you, Your Honor.
And magistrate item number 32 and 33, we have.
Are we almost done?
Yes, that is the last two.
Okay.
Mhm.
All right. So this, why are there so many businesses in North Miami called Prestige?
I
I
believe
mean-
it's one of the property owners. That's his business names. Start with Prestige.
Yeah, and somehow they all end up before me. So it's the opposite of prestige when you have so many violations. But anyway, this one deals with balconies, stairways, walkways installed without permits. This is case number 32. Tell me
Yes.
about it.
The building official mayor will be presenting item number 32, which is case number is MHVIO 2020-00245, and item number 33, case number is MHVIO 2020-00246.
Mayor Jean, building official, with the two properties, item number 32 and number 33, they were properly served, but still not in compliance for these two properties.
Okay, can you show me some pictures?
I'm putting the pictures up. Give me one second.
Okay, yeah, here's the pictures there.
Can you see it, magistrate?
Yeah, I do now. Okay. So all of that work that we see there, everything there was done without permits?
Special Magistrate, give me 1 moment.
Okay.
In the
Yeah,
meantime,
Special Magistrate, so they applied for a permit, but that permit was never issued.
Okay. Why
It was-
not?
The items were not complied with, and I think it has to be, I think there were also some county, I believe it needed county approvals as well, but because of with this one, it was work after the fact, and they had major renovations. So with the after the fact permit, it was never followed through in order for them to, for the permit to be issued.
To be realistic, how much time do you think they need in order to get those permits issued?
I mean, this has been going on for a long time. I mean, there's really, you can move to, whatever actions you need to do to get for them to get the picture, because it's been a while since 2020.
I see that.
Yeah, photos.
But has there been any ongoing work, or is the construction delayed, stopped?
Well, the construction is completed and the property is occupied.
Oh, I thought it was still under renovations.
No, the work has been completed.
Okay, so now they need an after the fact permit.
Well, they applied for it, and just the follow through to complete it.
Okay, so I'm gonna give them a short window there to do that on case number 32. Anything else you need to say?
No, that's about it, Special Magistrate.
Okay, based on the unrebutted testimony of the city's code compliance officer, the photographs and the evidence presented depicting that the cited violation still exists, proper notice has been given. I find in favor of the city enter an adjudication and set a compliance date of September 21, 2023. In the event of non-compliance, there shall be a daily fine of $500 until the violations are corrected. 23 permits for central AC replacement in progress without permits.
So this again was tied to the renovation that was done to the property, and again, all the work was completed with no permits in hand.
So the same thing as before, they need permits.
Yes.
All right. Based on the unrebutted testimony of the city's code compliance officer, the photographs and the evidence presented depicting that the cited violation still exists, proper notice has been given. I find in favor of the city entering adjudication and set a compliance date of September 21, 2023. In the event of non-compliance, there shall be a daily fine of, what was my fine on number 32?
500.
500, that's the same fine, 500 until the violation is abated.
Mr. Special Magistrate, is it possible you can ratify the fines to make it higher so they get the picture? Because
well, I can't ratify the fine. I can make the fines higher.
Higher, yes, sorry, higher for if they don't comply.
I'll tell you what I'll do. I'll do that on the first one, because they involve a lot more work. I'll increase the fine on 32 because it involves quite a bit more, and I think you prefer that they do that in more than in 33, which is basically a central AC replacement in progress. So I'll do $1,000 in 32, and we'll keep 33 at 500.
Okay, thank you.
Okay, and I'm giving them a very short window, which is September 21. I'm willing to do it earlier if
yeah, do it earlier, because I doubt they won't.
Okay, so what's Madam Clerk?
August 17th.
August 7th, maybe it'll go before a different special magistrate. August 17th, we'll do August 17 instead of September 21. Yeah, is that my time also?
August 7th, no, actually, with the August 17th abatement date, I can go ahead and schedule it for the September 7th or the September 5th hearing.
Is that my hearing or someone
Yes, it
else?
is. It's your hearing.
Okay, perfect. So it stays with me, and we'll do the abatement date August 17th, you say?
Yes.
Okay, so that's kind of a fair compromise, Mari.
Thank you.
$1,000 on the first one, 500 on the second one, and an abatement date of August 17. And again, Madam City Attorney, send some letters out and put the fear of God into them.
Yes, Special Magistrate.
Okay. Thank you.
And Magistrate, that concludes all the items.
Excellent. With that said, this meeting stands adjourned. We'll see you next time.
Have a great one, everybody.
Thank you.